Hi, my name is Michael Burgis, and I'm the managing attorney of MB&A. I'm a certified legal specialist in California workers' compensation and a trial attorney. I want to take a few minutes to briefly talk about some recent case law that has come down. This is the case of Zarafi versus Group One Automotive, which isn't a published decision, I don't believe. So it may not be binding and it may not be citable, but I want to go over the holding with you because it's applicable. It's important because there's a plethora of case law that's coming out discussing Labor Code 4660.1. This is essentially Senate Bill 863 changed the law, and it bars psychiatric compensation for permanent disability if it's a compensable consequence of like an orthopedic injury or another non-psychiatric injury. So you got Senate Bill 863 that basically took away compensation for permanent disability on psych, sleep, and sexual dysfunction. And if these injuries and resulting permanent disability is a compensable consequence of that industrial injury, we're not entitled, or the injured worker is not entitled to the permanent disability. Now, they are absolutely entitled to the future medical. And defendants often try to dispute this. They're wrong. And we just recently saw in the case of Lopez versus General Waxco that carriers trying to say that an injured worker is not entitled to temporary disability. That is also incorrect. Regardless of whether the permanent disability is compensable pursuant to 4660.1, temporary disability is, and so is future medical. Now, 4660.1 has a few exceptions, okay? Really two main ones, and one is a violent act and a catastrophic injury. Now, if your psychiatric injury, or rather if your industrial injury is determined to be either a violent act or a catastrophic injury, then the psychiatric permanent disability is compensable regardless of whether that was a compensable consequence of the original injury. Now, what Labor Code, or rather what this case Zarafi versus Group One Automotive is really adjudicating is the ambiguity of what is a violent act, what constitutes a violent act. Now, the seminal case was called Larson, and that was pretty vague and pretty open-ended, and quite frankly, I believe very much in injured workers' favors. Now we got a series of case law, including Zarafi versus Group One Automotive, interpreting as to what really constitutes a violent act. Now, the Larson case was somebody getting hit by a car, and so do you need to get hit by a car? What constitutes a violent act? Now, this case basically found that the injured worker did not qualify for psychiatric permanent disability, and what it really looks like it's focusing on is on the fact that the injured worker didn't lose consciousness. And it looks like there's a whole bunch of case law coming out, and what my opinion, as well as California Applicant Attorneys Association opinion is at the last legal conference, is really the dichotomy or the split here is based on whether you lost consciousness or didn't lose consciousness. So this is where Lauren comes into play here. This is where an injured worker is hopefully represented by adequate counsel who can make an analogy to their injury and try to substantiate and show that there was a loss of consciousness, and that loss of consciousness is in line with the case law determined that it did qualify for a violent act. And if the injured worker didn't lose consciousness, maybe make an analogy to something to distinguish this holding, but keep in mind this holding is not published, which is a good thing for injured workers. So once again, to reiterate, Zarafi v. Group One Automotive is a bad case for injured workers. It doesn't look like it's citable because it doesn't appear to be a published decision, but it is a good case to really educate injured workers out there as to what constitutes a violent act. And once again, a violent act is an exception to Labor Code 4660.1's preclusion of psychiatric permanent disability. If you're an injured worker and you're watching this video and you've sustained a psychiatric injury that you think is a compensable consequence of the original injury, usually an orthopedic injury, the case law is changing day to day, and the code is very much not in your favor. I strongly suggest you get a good attorney who knows what they're doing, because they can take this case law and they can advocate for you and try to argue that your case is either a violent act or a catastrophic injury, or frankly a direct injury, which would mean it's not a compensable consequence. If you guys have questions, I have the answers. Please feel free to give us a call. Absolute free consultation, and believe me, you got questions, we definitely have the answers. Thank you.